Every week in Queensland, millions of dollars are spent on thoroughbred racing, on the horses and the racing themselves, and millions more are spent on the gambling industries in which people cast bets on the races. Anything relating to gambling requires regulation, and when thoroughbred racing regulation in Queensland fell apart in the 1970s and 1980s, it was part of a massive network of corruption which went to the very top of the Queensland government. One of the most corrupt players was the racing minister Russ Hinds, who died before he could be brought to justice. A feature of the new administrative regime designed to remove corruption in racing was the implementation of more professional arrangements for the management of the industry. Queensland Racing Limited was created to oversee all thoroughbred racing in Queensland. The position of Director of Queensland Racing therefore carries significant responsibility. Directors serve for a fixed term, and the Constitution of Queensland Racing Limited prescribes how vacancies for director must be filled. William Andrews, the plaintiff in this matter, was due to finish a term as director, and he had, quite properly, applied for reappointment. There were other applicants, and the board placed the shortlisting process in the hands of an expert recruiter. Mr. Andrews was not the successful candidate, and he challenged the selection process on the basis that the requirements set out in the company constitution had not been met. Early in the judgment, Justice Wilson set out the approach that he would take to determining requirements under the Constitution. By virtue of Section 140 of the Corporations Act 2001, the Constitution takes effect as a contract between the company and each member, and between the company and each director. Therefore, it is to be construed according to the rules of construction applicable to contracts generally. It should be regarded as a business document and construed so as to give it reasonable business efficacy if such a construction is available on the language used, in preference to one which would or might prove unworkable. The judgment makes it clear that the company constitution acts as a contract between the company itself and its directors, and it is enforceable like any other contract. In this case, the court found that the selection process had not been conducted in accordance with the rules, and the company was required to reopen the selection process.